Obesity in America is unfortunately going up in terms of the number of people considered obese. But when does it impact your job? And if you're fired, is there recourse? A woman who was fired from a job claims it was discrimination for her obesity. But her employer says she was fired because they think she put a tape recording unit to hear them talk about her secretly. Joining us on the KOGO Newsline is employment attorney and business ethics professor at the Fowler College of Business at San Diego State, Dan Eaton. And Dan has a piece on this in the Union Tribune today. And Dan, briefly lay out what the issue is.
Well, the issue is that this woman was working at the Berkeley Tennis Club up in Northern California, and she claimed that the new manager did certain things that reflected a disgust with her size, such as ordering uniforms that were 5 sizes too small and making comments about whether she'd ever considered weight reduction surgery. She says that she was denied of certain job opportunities as a result of this, and she was ultimately fired, but the company says that her weight had nothing to do with it. It says that they reasonably thought, based on some observations, that she planted a recorder at a meeting that the board was having, presumably to pick up disparaging things she was saying about it. So there were a lot of interesting legal questions that came out as a result of this woman's lawsuit.
Well, I can think of several questions. One of them, can you talk about their weight in such a fashion?
And that raises, Marilyn, the very threshold question of whether severe obesity is even recognized as a disability. And the answer to that, according to the California Supreme Court, and this ruling was reaffirmed in this ruling late December by the Court of Appeal, is it is a disability if it has a physiological cause, but not if it doesn't have a physiological cause. What does a physiological cause mean? It has to be related to something like your musculoskeletal system, your digestive system, or what have you, rather than issues over which you may have control. And so the question is whether she had shown enough to indicate that it had a physiological cause, and the Court of Appeal said that she had, that she was entitled to a jury on that. That's one of the threshold questions. But as a matter of prudence, it's not a good idea to ask people about their weight, because you don't know what the cause is, and if it has a physiological cause anyway, it could be a protected disability, and you can't discriminate against people for being in a protected class.
So I'd imagine you would have to prove that you have a physiological cause to your obesity. What are the other legal issues that came out of this particular case?
Well, one of the issues is whether the tennis club really reasonably believed that she planted a recorder. What she said was, first of all, she didn't plant a recorder, and that what they saw her doing with respect to making some movements behind the bar where the recorder was found was she was actually just pulling some rags to clean up some tables after the board meeting. She was an at-will employee, so she could be fired if they reasonably believed that she had engaged in wrongdoing, even if it turns out she hadn't engaged in it. But there was some evidence that, no, they didn't really believe that she had planted a recorder, because they knew that there was an innocent explanation for why she was reaching behind the bar where they had found the recorder, and that they fired her anyway because they didn't like the fact that she was severely obese.
Now, what happens next with her case?
Well, it goes back to the trial court for a trial. That's what the Court of Appeals said in overturning the dismissal of most of her claims. They said, look, she had shown enough, for example, to present claims of discrimination and to present claims of defamation and harassment based on her severe obesity to a jury. So that's the next step that ultimately happens. But this is a very dangerous area right now, and the fact is that given the loosening of what it means to have a disability under state and federal disability law, the whole area is evolving, and employers should proceed with caution. There are going to be a lot of lawsuits concerning discrimination based on disability generally as a result of the broadening of what it means to have a disability. And understand that what is protected is not only actual disabilities, but also perceived disabilities. So even if an employer perceives that you have a disability that you don't and takes adverse action, such as firing you because of it, there could be liability. So there are all kinds of fascinating issues that are wrapped up in this 42-page opinion that was just issued late December of last year.